WDXE.
Hey, that's us, WDXE, and we welcome Stan Pierchoski into the studio again this Friday morning for estate planning with Estate Plan Stan, and we welcome you in, brother. How are you?
Oh, I'm fine. Good morning, Jeff. How are you?
Very well. Did you have a good week so far, my friend?
Had a very good week.
Well, very good.
A lot
very
going
good.
on, both professionally and personal.
Hey, there's a lot going on. There sure is.
Oh gosh, we had I had an air conditioner that was giving me trouble, and I tried to get it fixed during the cold months. So it was acting up last year,
Yeah.
It was still running, but it was hard starting, and so I measured it, and it was pulling way too much power to start. It blinked the lights everywhere, and I thought, okay, let me fix this before the hot season comes. So I got somebody out there like, oh no, you don't have to replace it, just do this. Well, it did something, in my opinion, kind of made it worse, and so I had to deal with it. And I finally got a new unit, and a fella had to help me put it in, and so it turned out we did it Wednesday. And so we had to turn everything off, and of course we were without air till the next day because you got to draw a vacuum. It's got to be there for like 10 hours overnight and stuff. And I was all ready to say, okay, I'll have to cool the house some other way. Well, it was the perfect day to not have air conditioning because it was the day that we had the storms. But I mean, it was rainy, never got above 83. We were sitting in the living room that night and said, well, there's no need to go get a window unit and put it in or anything like that. I had one out in the shed, and I thought I'll put a window unit in the bedroom. Never even needed it. It's like, couldn't have worked out better. So
well, that's good.
Then the next morning they came over and they put the gas in it, and it's up and running, and everything's fine now.
Well, good.
And it's a new unit, and they're kind of expensive, but I got looking at that one, and I remember putting that one in, and it turns out it has been there for 24 years.
Well, then you got good service out of it.
I think I squeezed. It was actually still running I just didn't want it to just completely die.
Yeah.
And then you have to deal with it at that moment. So at least we got it prepared. So anyway, let's get back to our bulletproof estate planning show. And as Jeff said, my name's Stan Pierchoski from Pierchoski Estate Law, Pierchoski Elder Law. We do this show every Friday from 8 o'clock in the morning to 9 o'clock in the morning. It's just a show where we talk about anything and everything estate planning.
That's right.
It's an interactive show. We encourage call-ins.
Right.
If you want to call in, that number is 931-766-9393. Easy number to remember. And just ask a question. We had one last week. It was a good one. We talked about it for a while. If I remember right, that person hung up before getting the answer, so I hope they kept listening to the radio to hear the answer. Yeah. But a couple of things I want to cover before we start talking about other stuff, and that is we have a seminar coming up. It's going to be a week from tomorrow. So
Okay.
August the 19th, which is a Saturday. And when we do our Saturday seminars, we do them at 10 o'clock. But this one, we're going back to Franklin. It's up north a little bit.
Oh, okay. Very good.
And it's at a place called Suite 501. The actual address up there is 416 Mary Lindsay Polk Drive. And it's in Franklin. There's a little strip mall. And at the end of it is a place they call it 501, and it's kind of a rental meeting place.
Yes,
and it's nice. It's not as big as when we use WLX Country Cafe or the Star Theater in Pulaski, or when we go to Columbia. It's got a limited number of seats, but it's around 50, and that's usually around where our attendance lies. So if you want to come to that, RSVP and get on the list, as soon as possible by calling my office at 931-363-7222. And get on that list. So that's Saturday the 19th at 10 o'clock in the morning up at the 501 Suite in Franklin. So if you need information about that, just call my office and talk to the girls. They'll be glad to tell you whatever you want to know. All right, so, when I do this program, I don't like to structure it too much. I just kind of like to be freewheeling. We talk about stuff. If people call in with issues, we'll just kind of focus on whatever that subject matter is. But
absolutely,
if there's, if we're on our own, then I just sort of like bring some topics that I'm going to talk about. And what I want to start out with today, and you always have questions, which I appreciate, because you're in the real estate business and land, although I'm not in the real estate business. Some people think estate planning means real estate. We do a lot of deed work, but the only thing we do is transfer the deeds into the trust. I don't do the real estate work. So anyway, what I want to, forget what I was going to say. I had my own senior moment there.
Well, when you're talking and you say I've asked questions, it's because something, it reminds me of something, and I think of something like, well, I need to ask you about that.
Yeah, right, and feel free to. So I'm going to go over something now. I know this show, we just started doing this maybe 2 months or so ago. It's like somewhere around June or something. And so, people may not have been listening from the beginning when I talked about some of the topics I talked a lot about wills in the first couple of shows, what made a valid will and stuff like that. And, if you've just picked up and haven't been listening, I get it, because this is a new changeover here at WDX.
It is.
But I want to go back and visit something, because one thing I like to do for my practice and for my clients is I keep track of court cases that come out and opinions when they're in this area. Now, I really look at many other states, because there's a good 20 or some states that have very similar laws to ours,
Right.
both in trust writing and long-term care planning and that sort of thing. So I keep up with those because they're very helpful, because when you read a court decision, that is law. Okay, their decision is law. And if they're, it's what they call stare decisis. It means once settled, always settled. So when you read what they say, they don't usually just come up with it then. They'll give an answer to a question, and then they will cite a case that they did 10 years ago.
Yes.
And that case will cite a case 20 years before that. So they don't make new law. They just stick to what is already done. Now, every once in a while, you can have what is called a question of first impression that they've never answered before, and then they will. And then that'll be the one you get from there forward, unless there's a reason to change it. But nonetheless, the whole reason I look at court cases is because, if you do what the people who win do, we know the courts will enforce that position. They'll support it. Sometimes the court case will say, sorry, the appellant loses because they did this or didn't do that. Well, you can learn from that. If you know what they're not going to support, we can fashion what we do to be in line with what the court has determined to be law. So anyway, this is kind of a case about a will, about the validity of a will. It's got a couple of take-homes out of it, so I'm gonna give the Reader's Digest version. If you want to know the citation, and if you're like me and kind of a geek and want to read it, I'll give you the citation. You can look it up. But it's fresh off the presses. It was just issued from the Court of Appeals out of Nashville on August the 1st. I forgot my reading glasses, but I'll do the best I can. On August the 1st, well, that makes it barely a week old, right? So it's right on the presses. But it's called the In Re Estate of Darrell Washington, and what this had to do with, it's out of Davidson County, and here's what happened. This gentleman had a will, and I couldn't tell by looking at it if it was like an online version or not. And the reason I couldn't tell is because typically on any kind of a will or document, it will always have prepared by and then the attorney's name and address, and we're pretty much required to do that on documents if we make them, right? So, if I do a power of attorney or a deed, it will always have the language, this instrument prepared by, Pierchoski Estate Law, Stan Pierchoski, that sort of thing. And I didn't see anything on this. But it looked a little better than what you can get online, is what I'm saying. You know what I mean? So
Sure.
I couldn't tell. But nonetheless, there was a will. And at the bottom of the will, and you get to the last page, and this is not about what was in the will. This is about whether or not, when this went to probate, because remember we talked about if you have a will, you're going to probate. So the probate court one of the first things they have to determine is the validity of a will. And then if they consider it valid, then they publish it with the probate estate, and then you move on with the probate process. So they present this will, and it got challenged. So that's how it gets in court. Okay, the court has to decide. Now, the will, it was like 11 pages long, and the court goes through it to say, okay, on page 1, it looks like the beginning of the will, because it starts out, this is my last will and testament, and I hereby, this supersedes all prior wills and codicils and all the standard language.
Right.
And they something I thought was interesting. I was sort of reading between the lines. They said they'd comment the pages were not numbered, and they kept saying, "We assume this is page 1 because of this. We assume this is page 9 because this is the end of." And so, to me, I'm thinking to myself, I'm glad I numbered my wills, and I'm going to continue paging my.
That's a good idea.
Doing that, because I could tell they were a little bit frustrated, but they didn't really say anything other than they were unnumbered, and we assume this is page this is page that. So anyway,
Yes.
We don't want them to assume anything really. So anyway, they said this page 9 looks like the end of the will, because at the bottom it says, I hereby attest that the foregoing is in fact my true last will and testament, and it gives a date and a signature line, and underneath the signature line was the person's name, Darrell Washington, and there was nothing there. It was unsigned. It was dated, but it was unsigned, which also tells me it couldn't have been done in front of an attorney. I can't imagine any attorney being that incompetent to not let somebody sign the line on a will that they just prepared for somebody.
Yeah.
So it looks like it might have been a do-it-yourself, but I just wasn't able to figure that out. Anyway, it was unsigned. Now, here's the interesting part. And I talked about this when I talked about wills, but every will should have at the end of it, a page called the self-proving affidavit of the witnesses. Because, what makes a will valid is it has to be signed by the testator, and it has to be witnessed by two witnesses, and all the signatures and stuff have to be done in the sight and presence of each other.
Okay.
That's what makes it valid.
Okay.
Not notarized. People come in all the time and say, hey, Daddy died, and here he wrote this will, and he signed it and notarized it and everything. And it's a piece of tablet paper, and it's got his signature and a notary stamp on it. And it's like, that's not valid. Notary doesn't make it valid. Notary isn't required in the statute. The statute says it's got to be signed and witnessed. That's what makes it valid. And so, and that's kind of where we're going with this, how the courts interpret this. So they looked at that, and I thought, uh-oh, this is not looking good.
Yeah.
Because as I'm reading, and I try to guess how they're going to rule before I hear the answer to the question.
Yeah.
But I'm thinking, okay, this is not looking good because I know what the statute says, and he did not sign the will. So I'm thinking on that alone, they're going to invalidate it. So, but what was interesting was now they have the self-proving affidavit of the witnesses, and the witnesses sign this, and the witnesses' signatures are notarized because that thing at the end of the will is in the form of an affidavit, which is a sworn statement. So that is notarized, but it's the two witnesses being notarized. So what's the purpose of the self-proving affidavit? There's like 5 statements in there. And every time I do a will, for a will to be the formal execution of a will, and for it to be valid, I tell the individuals, I've got to make this little speech. I'm going to do it out loud. You have to answer me out loud. And it has to be done in the sight and presence of both you, the signer of the will, and the two witnesses. Okay?
Yes.
And so I give a speech something like this. I say, you are Jeff Hood, and you are purporting this to be your last will and testament. Is that correct? And you say, yes. I say, and you're doing so in the sight and presence of two witnesses. Yeah. And you are purporting in the sight and presence of these two witnesses that you are of sound mind and disposing memory. And what that means is you know and understand your property.
Yes.
You understand the relationship of the people you named in the will and fiduciaries and beneficiaries. And you understand that we are putting together a plan that distributes property after death. And so I will ask the question, do you know what we're doing? And
Yes.
they say yes. If they say no, we got to stop. But okay. But if they say yes, the good yes. Then I say, and you're going to be signing it in the sight and the presence of two witnesses. I name who the two witnesses are. Yes. And I say, okay, and now the two witnesses are these two people, and they are going to be signing it in the sight and presence of both you, the testator, as well as each other. And then that's the end of the statement. Now, the self-proving affidavit has all those things written in it, and then they sign it as their testimony that all that actually happened. And the reason we do it is this. When you prove a will, you have to prove the witnesses.
Yes.
Now, if you didn't have a self-proving affidavit, to prove the will, you'd have to drag the two witnesses into probate court to prove that they signed it and that all those things actually happened when they were there. So we do this. What we do is this is like a testimony. It's an affidavit. It's a sworn statement.
Yeah.
So if the people die and you can't bring them into court, you can bring in their affidavit. And because those are the questions, if you did bring them in, those are the questions you would ask them. Did this happen? Did this happen? And did this happen? And the affidavit is a sworn statement saying, yes, it did happen. So we can bring their testimony in and offer it to the court, and the court will accept that as proving the witnesses.
Sure.
So that's why we do that. The only reason I go to that much trouble explaining it is because that has something to do with this case. Well, on the document where the two witnesses sign it, there was a line for the testator to sign, which I don't do because it's not necessary to be there. Now, if it's not necessary, then it's not a mistake to do it. It's just kind of superfluous, right? Like worst case scenario is it has no effect, right? it doesn't really do any harm for it to be there. But I don't do it because it's not necessary. I have the signature on the will where the statute says it's supposed to be. But on this case, the gentleman did sign the line on the self-proving affidavit. So the question was created, and what the argument was about the parties was, it was on the instrument because it's on the self-proving affidavit, which they claim is part of the instrument. So even though he didn't sign it in the first spot, signing in the second spot was good enough. And of course, the other party said, no, it has to be on the will, right? So anyway, the lower court, Davidson County, Circuit Court of Davidson County said, no, it's not a valid will. And so they appealed it to the Court of Appeals. Not our Supreme Court, but the next level up, one below the Supreme Court. And they dug into this and they said, okay, they said, well, one thing that was interesting when they talk about trust, they say when we interpret a trust, the trust law says we're supposed to interpret it, we're going to focus on the intent of the trustor, the maker of the trust.
Yes.
But when you talk about a will, They say wills are formally executed documents, and the legislature has the power to describe what's necessary to make a valid will. And they did. And they said because they're formally executed, they've enjoyed decades, if not centuries, of abuse. We interpret wills with strict compliance to the statutory rules. Strict compliance. That's one of the takeaways about this. Okay. And so the question, so they say, okay, the question is the testator signing the self-proving affidavit in strict compliance to what the rule says he has to sign the will? Okay, so they go into this analysis and they talk about it and they read the words on there, and there is a page that appears to be the end of the will. Right after his signature, it says, this is my will and testament, and this is the entire will and testament. I hereby sign it as my free and voluntary act, and there's the signature. And they'd say, and that looks like the end of the will. And then after that is a document, and it's got a title on it. It's called Self-Proving Affidavit of the Witnesses.
Okay.
And the witnesses sign it and say, I have signed this instrument in the sight and presence of, all that stuff I just said, right? And then the testator signed it. So I have signed this in the sight and presence. I signed this instrument in the sight of the presence of the two. And so the court focused on the fact that the language said, I have signed this instrument. And so the bottom line, and I thought, okay, I know how this is going to turn out.
Uh-oh.
The bottom line was they said, this instrument was the affidavit. It does not make reference. If it had said, I also am signing as if it was the foregoing will or something, they don't offer much of what they could have done. I'm sort of filling in that gap. But they said the strict compliance of the rules. If this says I signed this instrument, the self-approving affidavit, it's not there that we can extrapolate that and say it also includes the document in front of it, which was the will, which had an ending.
Wow.
So they said we uphold the lower court's decision. This is not a valid will and cannot be admitted to probate. So
how about that?
This person is either going to go into probate with a prior will, if it was valid, or no will. So I guess the takeaway is this. If you come to my seminars or you listen to me on this program, you're going to find out pretty soon that I am not a big fan of wills. I kind of beat up on them kind of hard, to be honest with you. I think they're a step in the right direction, but that's about it. They are formally executed documents. They are cumbersome. They are riddled with these kind of strict compliance, any one of which will invalidate them.
Well, you're swimming against the grain a little bit.
Yeah,
because I think the prevailing mentality is that everybody needs a will, period. And so that's been kind of the way to go for so long that everybody thinks, well, we got to do a will. We got to go get a will done.
And again, there's nothing wrong with that logic. But if you do a will, it has to be done right, or it's going to fail.
Yeah.
And I always tell people when I give that speech, everybody half the time they chuckle and like, this is kind of silly, and it makes me feel kind of silly to do it. But at the end of it, I say, listen, if I don't give that speech, and somebody can prove that I didn't give it, it is fatal to the will. The statute requires that be done. And as you can see here, if you do exactly what the statute does, we'll say, okay, the will's good. If you don't do exactly what it does, we're going to say it's no good. Yeah. So it's a harsh result. So this is not a good place to be do-it-yourself. Or in my opinion, legal Zoom wills. I mean, legal Zoom wills say, no problem, we do it valid in all 50 states. All 50 states have 50 different rules on their wills. Now, they all come out of our common law, and they're all kind of similar. But, in our statute gives the actual bare minimum of requirements. But you got to at least meet those. Now, here's a case where, I really can hardly believe this was done through an attorney. But the way it was written, it looks like it was. So I don't know. But this is a gross mistake to not sign the actual document. Yeah. I mean, there it was bigger in Dallas. There's this line with the guy's name under it. Above it was the date was filled in. And it didn't get signed. And it's a colossal blunder.
And it's totally left to speculation as to why it wasn't signed.
And it doesn't go into why would someone challenge a will like this unless there was a fair amount of property to deal with. Okay, and somebody probably took better if there was no will at all or a prior will. I mean, you don't drag this stuff into court and subject you and the parties to this kind of expense because this is not cheap. Yeah. To go to the Court of Appeals. If you're fighting over nickels and dimes, right? So, but the point is, they're going to construe these things with strict compliance. Now, the difference between the will and the trust from the legislature and the court's position is when they do the will, strict compliance with the statute. With the trust, the statute says okay, so I guess you could say, yeah, they do it with strict compliance of the trust rules too, but the trust rule says, the statute says that the trustor's intent is paramount.
Yes.
And so they're going to say, if we can figure out what the person meant to do, that's what we're going to support. And I have seen some really places where I thought they were stretching to get to the test. There was one where there was an amendment the guy did. He had it written out, he initialed it, but he never got around to actually executing it, signing it. They brought in people to testify what he did, and they said, as far as we're concerned, he intended to make the change. He just never got around to doing the actual thing. So we're going to consider the amendment valid because his intent controls. And there's overwhelming proof that the intent was there.
Yes.
So, you can see it's kind of a wide open field. And
Right.
we treat these like they're formally looked at. We don't leave things to chance, but the intent is what they will uphold to the trust. Now, the intent is something we have to make sure we can relay in the document what our intention is. So like if you want to disinherit a child, I bring that up because it's something we see a lot. In a will, you can say it, but the court will still entertain a challenge for that because a child's a natural error under the probate code, and you have to have some indication that was what you wanted. So you have to say right in the will, I disinherit the person.
Yes.
In a trust, we say the same words, but all we have to do with the trust is we have to make any indication that you intended to disinherit the person, which means if you're silent about it, in a will, if you're silent, somebody can bring, let's say I have 3 kids and I say, this kid gets this kid gets this, and I'm absolutely silent about the third kid.
Yeah.
The third kid can say, listen, I was not mentioned, so I must have been overlooked. I'm a direct heir, and it must have been forgotten about. And the court will entertain that, and that can be successful. In a trust, if you're silent, the interpretation is their intention was to leave to these two, and they made that very clear.
Yeah.
However, I never am silent. You want to disinherit, I always say, let's put the name in there, and let's say, by no accident or mistake, I'm leaving this child nothing, or I'm leaving this child $5,000 or something, whatever.
Right.
And that way it's expressed, so you can't argue they must have forgotten me because it's expressed in the document. But the intent is clear even if you are silent. I just like to do a little overkill and just make sure our intent is perfectly clear that we tend to disinherit. So, or anything else you want to put in there, we want to drive this intent home and make sure it's clear. So we can learn from cases like this. I'm not trying to make this a law lecture. I'm just saying, and I do this for you. So if you come to me, I incorporate these thoughts into what we do.
Yeah, you don't have to learn all this. You just need to know somebody that knows it.
Yeah, and so I keep up with this because if something would come up, and I have fine-tuned some things over the years, but if something comes up that the courts say, all right, we're not gonna enforce this, and it's something I'm doing or not doing, I'm going to take note of that, and I'm going to start doing that. And if it's possible to go back and fix, if it's like a fatal mistake, if it's possible to go back and fix it, I will, because most trusts are amendable during life. So we can always. Sure. So that's part of what I do to make sure what we do is on track. And if it ever gets to court, I know what the answer is going to be. Because I'm going to say, hey, in this case you said this, in this case you said this. We did this, and I expect the exact same answer. So what are you going to do about it, court?
Right.
You can't go against what you give these opinions. I rely on them, so you now have to give me exactly what I want because I've done exactly what you told us to do. So it's the way to fashion things so that if you do get to court, it's pretty much a slam dunk win. And because of that, stuff never ever gets to court, at least the stuff we do. So it's interesting. But I just thought I'd bring that up because I know in one of my early episodes here at the WDXE, I talked about wills and I talked about the 3 kinds of wills and what made each of them valid. And we did talk about the what they call formally attested will, and what makes it valid. It's got to be signed by the testator, and it's got to be witnessed by 2 independent witnesses. Well, actually, it doesn't say independent witnesses. I always use independent, but it doesn't say. But they have to be, it all has to be done at the same time in the sight and presence of each other.
Yep, I've actually witnessed a will and been a party to that exact process.
Now, it doesn't say, interesting, it does not say a bare minimum is 2 witnesses. It doesn't say it has to be an independent or disinterested witness, meaning it could be an heir.
Yeah.
Now, I don't like to do that because that is too close to it. You know what I mean? For a witness to be somebody that takes in the will.
Yeah.
I like them to be independent and uninterested, so I actually have somebody that comes in my office that's available often, And most of the time, I'm the other witnesses. And I like to tell people, it's almost jokingly, I say, I'm an independent and an uninterested witness. Now, I'm not uninterested because I don't care. I'm uninterested because you're not leaving me anything.
Right.
I'm not part of the estate.
I'll have to say, the one that I signed, I was a little disappointed that it wasn't being left anything.
Well,
I'm just kidding.
I get it, but you know, when you look at some of the power of attorneys we have, the advanced care directive, the one you do when you get to the hospital, or if you have one ahead of time, they'll ask you if you have an advanced care directive, and that document, it says at the top of it, because the language we put in there, it comes from the legislature. There's a box at the top that says you can either witness it or you can notarize it. One or the other. It doesn't require both. You pick. But if you pick witnessing it, the witnesses have to be independent and uninterested, meaning they cannot be part of the estate or it's not considered valid. So, again, when people say things are notarized, let's talk about what a notary does. I know in real estate, you deal with notaries all the time.
All the time.
A notary simply does this. Now, I'm not being condescending to the notary. Let's just get right where the rubber meets the road. And what does a notary mean? A notary is sometimes called a verification. So if you ever seen a document, like I've seen in some other trusts that were written that says if you want to make a change to this, you have to do it in writing and it has to be verified. Okay.
Right.
What they mean by verification is a notarization. What all that the notary does, the notary doesn't read it. So if I take a trust to a notary, or let's take a deed, because we're talking real estate. You take a deed to a notary, they're not going to sit there and read it and say, well, I'm not agreeing with you transferring this property to this person, or no, I don't think the meets and bounds is quite accurate. They have nothing to do with the content of the document. What they do is they say, hi, I'm Jeff Hood. I want to notarize this document. Okay, Mr. Hood, can you please prove to me that you are who you say you are? And if she's never seen you before, you probably might have to show your driver's license.
Right.
And then when she verifies it and where she stamps it, language says, appeared before me, Jeff Hood, who satisfactorily proved to me that he was in fact Jeff Hood. But there's also some language there that says, or I knew personally, and he didn't have to prove it.
Right.
But either way, all the notary does is prove you are who you say you are.
Right.
And the person signing the document is who they say they are. And that's all. They don't review the document. They don't even look at it. And if they do look at it, you would be well within your bounds to say, hey, stick to the last page and stick to what you're supposed to do, which is proving who's the signed person. Right. And any notary will tell you that's exactly what they do. I mean, if they had to do something with the document, then they're entirely opened up to liability for the document, for crying out loud.
Yeah.
So, I mean, they would notarize a document that said you were the King of England if you proved you were the one signing it. It doesn't mean you're the King of England. It doesn't give any authority to the document. So
no, the notary's not validating the content of the document.
Right. But I hear people say all the time that my mom signed a will and we got it notarized and everything. And that I get it. So let's just it's just a misunderstanding. So let's get it cleared up and let's get it straight.
Right.
The notary doesn't validate anything. It just validates the signature, verifies the signature.
That's right.
Not the content of the document. So yeah, good stuff. And I think people, when it's explained, I think they get the idea.
Yeah.
So
I had a quick question for you too regarding estates in general, I guess, and because of just I think sometimes our mentality about it is there a value of assets that justifies the level of estate planning one way or the other, or anything like that, or is it? Do you understand my question?
I do. Sometimes people will say to me, "I don't have enough to do a trust."
Yeah, that would be a common question. I just don't know if I really need all that because I don't really have that much.
Well, here's my philosophy, and that is, if you're indigent and really have nothing,
yes,
I guess it wouldn't matter. But when we're talking, when you say I don't think I have enough to justify doing a trust estate, it's still you're not indigent. You're somebody. You probably have a house. You got a job. You own stuff in the house, right?
Sure.
I mean, you have some money in the bank. A lot of people say I don't have much, but you got some money in the bank. The size of the estate is really not a factor. What I think is the biggest factor is when you do a trust, that focuses on moving the property that you have to exactly who you want it to go to and how you want it to go to them. Right. So if you're rich and famous and you got a $100 million estate and it goes into probate court and everybody and their brother is fighting and arguing for 3 years, then you'll finally reach, okay, the estate finally got settled and it cost them $30 million to sell the estate. Well, there was still $70 million left for the heirs to go to, right? if you don't have much, it becomes more and more important that it goes to the people you want it to go to, because you can't afford to lose it in any kind of probate process
That's
or
a
any
good
kind
point.
of contested thing. So you're at more risk for it not happening if you have, but so you want a plan that's literally guaranteed to do what it, that will work when time comes to work. And that's what a trust does. A trust is a heavily enforceable document. They're very difficult to attack and defeat. And especially if you're complaining about how much you're getting or something like that. But so then it becomes very important that it all goes there, and there's not a consumption of it through some other process or somebody else's fees and stuff like that. So that's my philosophy. I don't like to think the size of the estate should be the factor. But again, if you're a very little, if pushing no means, it may be 6 of one, half dozen of the other,
Sure.
because you're not passing hardly anything. So how important is it that whatever you're not passing or very little goes to where it goes?
Right.
Or if it's going to be consumed in your final expenses, if all you own is a very little bit, it's all going to be consumed in your final expenses, then there'd be an argument for it's not necessary.
Sure.
And neither is a will, because the will just passes property after death, and if there's nothing to pass, then the estate becomes insolvent, and then you may have debt, but you can't pay debt if the estate's insolvent.
Right.
So, good question. It gets asked a lot.
All right.
So,
Hey, and by the way, the phone lines are open. If you'd like to talk to Stan or you've got a question yourself, 766-9393 is the number.
I keep forgetting to
Yeah.
interject the phone
That's
line
no problem.
halfway through. So.
No problem.
But you do.
But it's been a very interesting experience for me getting to know you and talk with you. I don't know if this is going to be a
You may answer.
question call or not. We'll see.
I drink a coffee.
And good morning. How are you?
I've got a question. Who's Jeff Hood?
Well, this is Jeff, but I've got Stan. I've got Stan here with you. Got a question for
Are you a
Stan?
real estate dealer?
I do sell real estate.
I thought you were doing real estate.
Yeah.
Well, who's that fella with you?
This is Stan Pierchoski. He's estate planning. He does estate planning.
Estate claimer.
Yeah.
Okay. Well, I was going to tell y'all something. I've been listening to you a few minutes, and I had a little trouble hearing a little bit. And, I'm working for one of the greatest real estate dealers there is.
Yeah.
Yeah. He's got a lot of property and owns everything.
Oh, I know that. Yes, right.
You know God and Jesus, don't you?
I do. Hey, I appreciate you, Nolan.
Have you thought about the real estate he's got?
He got the whole world in his hands.
The
doesn't
whole world in his hands.
he? All right. Well, thank you.
I was listening to that other man there. I can't pronounce his name probably.
Just Stan.
I was
How about
listening to
that?
y'all, but y'all talking about trust, wills, and deeds, or are you talking about what was he say he's talking about?
Well, he's talking about doing wills and estate planning and
Estate planning?
and trust. Yes.
Okay. What do you do? Well, I guess it's different. So, if you want to take some land off your property and run a deed on it, cut part of it off, you got to go to a different person for that, ain't you?
Well, that's a little bit different issue. We'll talk about that. Okay.
Yeah.
I'm gonna hang up and let you listen on the air. Okay.
Okay.
All right.
Well, thank you. God
Thank
bless you.
Yeah. Yeah, that is a little bit different issue. We would go to a surveyor. And,
That's right.
And create a survey and block off what you like to do. But that's just so. A lot of people's estates are wrapped up in real estate.
Yeah.
No doubt.
And like you say, if you're going to carve a piece out, you
Yes.
have to have what is called the meets and bounds description, because that's what describes your piece of property here on planet Earth.
Right.
Now, I enjoyed that comment, because I agree 100% with the gentleman that you talk about my land, your land,
That's right.
what I own.
That's right.
I'm not going to get into my deity, but my deity is strong, and I'm a staunch Christian, and none of this is ours.
Yeah,
we're given exclusive use of it, but we're just being good stewards of it. Is
That's
the thing.
right.
But in man's law, we talk about ownership and rights that you have with the property.
Right.
But all said and done with, there's somebody that claims ownership of all.
Well, the truth of the matter is, everything we have is his.
And what I do around the holidays every year, if we're still doing the show by then, I hope we are. I do it takes me about an hour. I can spend a show on it. I call it the biblical perspectives of estate planning.
Oh, that would be interesting.
And would you be surprised that the word inheritance occurs just under 300 times from cover to cover in the scriptures. So everything we talk about is nothing new under the sun. All the stuff we do, I can find an example of the original thought process of what we do.
Well, the whole idea of law came from God and the scriptures.
It did. And you talk about an inheritance, then you talk about a delayed inheritance, you talk about a unequal inheritances. I can come up with examples of all that. And that's what that's about. It's really kind of cool. Right? I enjoy doing it. So none of this is my idea. I don't take credit for the original thought. But again, yeah, you're right. I mean, in the grand scheme of things, none of it's ours, including if you want to get to an international level, and the countries claim, you're doing this to my country, or you're invading my country. If it's your country, it's your country by permission. That's what it is.
That's true. That's absolutely true.
And when that permission goes away, then I kind of don't want to be around. But,
it's good thoughts.
Yeah. But anyway, that's exactly right. So we talk about this. We're talking about what man's law allows us to do with real estate.
Sure.
And the rights that go with that. So
sure.
All right. So, do you have any other questions?
Well, it's all about he talked about dividing a piece of property and how that would happen. Well, that's what estate planning is too. You're dividing up your property, and it can include real estate, but it also includes other assets, which has been a question of mine too. Is once you have, once you have an estate plan, and you have a trust set up, and you acquire more and more assets as you live. What actions do need to be taken in order to make sure that those new assets are added to the trust that's already set up?
Okay, good question. When we talked about trust in general, we talked about you make a trust, but the moment you make the trust, it's kind of empty because there's nothing in it because you just made it, right?
Correct.
You couldn't have anything in it beforehand. So you make it. A lot of times I draw it on my whiteboard in my office. I'll draw a box and I'll say, okay, this is your trust. This is the Jeff Hood Trust.
Yes.
When we sign the trust documents, you've made your box, but the box is empty. So the next thing we want to do is move your property into the trust. We called that funding the trust. And when we talked about a deed, and we say, okay, to put a piece of property into the trust, we have to redeed it from you, Jeff Hood, to you, Jeff Hood, the trustee of your trust, because in the trust means we're going to vest the property with the trustee of the trust.
Right.
And that puts it in the trust. That's what in the trust means. And so let's say you do that, 5 years later, 10 years later, you're where you live, maybe the 10 acres beside you opens up and it's a good price and you think, you know what, I want to buy that.
Yep.
Go ahead and buy it. Now, there's two things you can do. One, the easiest thing to do is you've already got this trust. When you go to buy it and you get to the closing, right, just tell the people that you're closing with, say, oh, by the way, make the deed out. Don't make it out to me, Jeff Hood. Make it out to, it's from the person you're buying it from. Make the grantee Jeff Hood, trustee of the Jeff Hood Trust. And that way, when you acquire it, it is in the trust from the get-go.
Correct.
Now, if for some reason, I don't know why this would be, but if there's something happens, like you forget or somebody drops the ball, and they go ahead and deed it just to you, Jeff Hood, the cure is very simple. We turn around and just do another deed, just like we did the first time, and do a new deed from the same property from Jeff Hood to Jeff Hood, the trustee, and now that's in the trust. So, if you acquire new property like that, that's titled like that, you need to put it in there. If you acquire a brand new bank account somewhere, like let's say after you do your trust, you say, hey, this bank has got a great CD rate, I'm going to open up a CD account. Tell them when they say, who's the owner of the account? Me, Jeff Hood, trustee of my trust, and and it's there from the get-go. Now, acquiring other property, like personal property, which is not titled, you don't have to do anything with it. You just possess it. If you possess it, it's in the trust, because we have documentation that says anything you possess is in the trust. Because how do you put your shirt into a trust? It has no title ownership.
Yes.
You can't prove you own it. I mean, the way you own it because you possess it, and nobody else is claiming it. So, it's the old adage that says possession's 9/10 of the law. If you possess something, it's yours. So, it's kind of a snapshot in time because the stuff you possess comes and goes every single day.
Sure.
So, if something happens to you today, you hit by a bus, you're gone. That snapshot in time, whatever you possess is in your trust at that moment in time.
Okay.
So that's why it reaches into the future. And if you buy a four-wheeler or a Polaris Gator or something, the question is, how do I get it in my trust? take it home and possess it. It's in there.
Yeah.
It is that simple.
Very good.
It is that simple. But stuff like real estate and bank accounts, we have the deed, and with like a bank account, we have this contract with them. So we want the ownership to be showed as us as trustee. So there may be some upkeep, and I get those calls. And if I get the call early enough, I say, well, listen, when you go to the bank, just tell them to make the account in your name as the trustee, and it'll be there from the beginning. That works out great.
Quick question on the on that. We've still got plenty of time here, about 15 minutes left, and on most people, their home is their real estate, their home and their property there. Most people don't have multiple tracts. A lot of people do, but for the most part, the average family has their home, and for a lot of them, they have a bank note or a mortgage on this property. Can that property be put in a trust even if there is a mortgage? Or
Excellent question. Excellent question. It's a really long answer and can get very legal, but I can cut to the chase on it.
All right.
And
good.
the answer is yes. You can put it. The indebtedness does not affect putting it into a trust. Of course, when you put something into a lot of people say, I got my house, we own it free and clear. Great. We just deed the thing in there. Everything's great. But they'll say, I've got a mortgage on this. I'd say, okay. Well, when you put the property into the trust, you own the property. You just have a debt on it.
Right.
Now, the bank doesn't like take it away from you. I know people would argue with that, but the bank only owns the indebtedness.
Correct.
Which means they have the right to foreclose and sell, but if it sells for more than what they're owed, that money has to go to you because you own the house, but you owe the debt.
Yes.
So it can either create a deficit or it can create a profit. But so when there's no problem putting it into the trust with that indebtedness because you can only put into it what you own. So the question really comes around if suppose a person passes away while there's still debt on the property.
Yes.
And he says, I leave my house to my son. Well, the son gets the house, but there's still this outstanding note. Now, technically, if nothing else is done and he wants the property, he has to take the note that comes with it because if you don't pay it, they're going to foreclose. So there's certain things you can do. Prudent people will take out like term life insurance and say, I want this to pay the house off at my death so that my heirs get it without any encumbrances, that sort of thing. But there's several ways to do that. But yeah, you can certainly put it in. Now, what raises an interesting question is a couple of decades ago, when some folks were doing some trusts, most mortgages have a clause in them that is called due on sale. So if I have a house and I borrowed money on it and I've been paying on it and I decide to sell it to you, that sale triggers the due on. And there's nothing unusual with that because at the sale or at the closing, the money's going to be written out of the bank and they get paid off at that time.
Correct.
But what they're saying is they're not going to let the new person pick up the note. At least certainly without they can do that, but they're not going to let it happen automatically. It's got to be with their input.
Right.
So I don't run into too many problems when we leave an encumbrance to a child or something. The bank is usually pretty okay with that. But they can have a say in it. But what happened decades ago was some banks, when you would put property into a trust, they would claim that is a change of ownership. Now, you are kind of deeding it to yourself. So you're deeding it from Jeff Hood to Jeff Hood, the trustee of the Jeff Hood Trust. That is technically a change in ownership, a conveyance in property.
Interesting.
And so they were saying that triggers the due on sale clause. We want paid, and the person. Now, there's a difference when you're selling it to a third party because you have money from the sale to put towards the due on sale clause.
Right.
But when you're deeding it to yourself or to your trust, there's no real exchange of money going on, right? Well, there was a federal law that came down, and I'm not trying to be too heavy, but it's called the Garn-St. Germain Act. And that put the kibosh on that, where Feds said, because Feds control banking law.
Yes.
And they said, you cannot trigger the due on clause if, and there's a list of things, and one of the things they list is if you put it into a trust like that. So we've never had an issue with that. I've never experienced an issue with putting property in that has an encumbrance. I've never had a call from the bank that said that. Now, the only thing, well, I won't even go there. I was going to talk, in our asset protection trust, it may be just slightly different, but if you have an encumbrance on it, you want to put it into one of these revocable living trusts, it is not a hindrance whatsoever.
Yeah.
And I've never had a bank raise an issue with that, and there's no problem.
Do you deal mostly with revocable trust?
That is a big part of what we do. I don't know if it's mostly, but it's, I don't know. I don't know what the percentage is, but we do a lot of revocable trusts. And we do a lot of those asset protection trusts I talked about just a few weeks ago. One is revocable, one is irrevocable. They're both living trusts, but they work slightly different. One is a creditor protector trust. It protects you from your creditors. The other one does not. That's the only big difference between the two. And the one that's the creditor protection is the one we use to shield our property from the high cost of long-term care, which is kind of what it is. It's really geared toward any creditor, but that's the one most people are concerned about.
Sure. Now, is that the one you're calling the asset protection?
Yes.
Trust? Okay.
We actually call it the income-only asset protection trust. That's right.
Okay.
And we do quite a bit. We do quite a lot of those too. So
sure.
I don't know what the percentages are. Somebody in the office keeps up with those kind of statistics. I don't know.
Now, is that a different thing than an irrevocable trust?
That is an irrevocable trust.
That is an irrevocable.
We do a revocable living trust, and the asset protection trust is irrevocable.
Irrevocable.
Yeah. Now, let's talk about irrevocable.
Yeah,
sometimes people will say, what's the difference between a revocable trust and an irrevocable trust?
Yeah, I would like to
now, the answer,
parse that.
The answer is not. One's revocable and one's not.
See, you would assume that would be the answer, but that's not the answer.
The big difference between the two is an irrevocable trust. You, the maker of the trust, cannot be the beneficiary. That's in a nutshell the difference. So if you do a revocable living trust, which we do a lot of, they're grand instruments, but you are all three parties. You're the trustor, the maker of the trust. You are the trustee, the one who controls the property, and during your lifetime, you are the beneficiary.
Okay.
Now, your children are beneficiaries too, but they're not beneficiaries till after death. And so you're all three parties to this agreement. When you have that much access and control over property, and if you're all three parties to the agreement, you have completely unfettered, unhampered access and control. You do whatever you want with it. You put it in, you take it out, you sell it, you buy more, you change it, you lease it, you rent it, you burn it. You do anything you want to do to the property, and there's no limitation. When you have that much control and access to property, you're not going to get creditor protection because if you have access to it, so do your creditors.
Okay.
So we create the irrevocable asset protection trust, and we limit our access to the property because we sort of create that situation where if we can't get at it, then they can't get at it, meaning your creditors.
Right.
And that requires an irrevocable trust, which is not that big a deal. It's just that you're not the beneficiary of it.
Right.
Okay, you can leave it to your kids all day long. They can be beneficiaries, but
Right.
you cannot. And by giving up that little something, I guess I do it at my seminars. I say, if I hold my left hand up in the air and say, if you want all access and control, then I hold my right hand down and say, you get no creditor protection. If you want to get creditor protection, you got to give up some access to make it work.
Yes.
It's a fundamental nature of property law. If you have property and you have a valid creditor, they have rights to access to get at that property to be satisfied, assuming it's a valid creditor. But if you don't have access to it, then they can't get it. If it's in a trust for your benefit, then it's in the trust, and it's not a loophole or anything. I mean, trusts have been around for centuries.
Sure.
For centuries. We have just started using them for asset protection here since the '60s when we came out with Medicare and Medicaid. That's all. I mean, they have a use for that. This creditor protection thing is nothing new under the sun. I mean, these trusts are referenced all the way back in our Magna Carta. There's a long common law history of this stuff. So, not sure how we got on that, but we were talking about the indebtedness. But yeah,
I threw questions.
I know, but I love it. I mean, I love talking about it.
Yeah.
The question was, what's the difference between revocable and irrevocable?
Yeah, and
now,
you'd covered that, but actually, it had to. I hadn't really let it soak in like I should have. And so that was just, I was like, okay, now what's the difference again? Because it was like I have to take the class again. So.
But an irrevocable trust, people feel like, well, there's nothing I can do. I can't change it. I can't modify it. It's cast in concrete. Not really so. I mean, one thing you can change on an irrevocable trust, typically, unless there's specific tax trusts where you can't, but I don't even do that kind of stuff. But you can usually always, or at least ones we do, you can always change who the beneficiaries are and what they get after death.
Okay.
Which is what most people change. What you can't change is, the trust says you have no access to principal. You have control of it, but you don't have any access to it.
Okay.
If you want access to it, you got to get it that indirect way I was talking about before. So what you can't do is you can't do this trust and 2 years later say, okay, I'm going to amend my trust to say, no, I can get this direct. I can just take it out and give it myself and everything will still be creditor protected. You can't change what makes it work. But you can change where it goes after death. So if you got 3 kids and you say all these 3, they all get a third. Right. And after you make the trust years later, you say, you know what, mad at my one kid and I want to leave it all to the other two 50-50. Well, you can make that change to it.
Yeah.
And you can turn around and change it back. But we're not dealing with the heart and soul of what makes the asset protection trust work. We're dealing with where the property goes after death, which is not a because it has to go somewhere. And the creditors we're worried about are not really in the picture then at that point. So
Yeah.
So, and the other thing is, this always surprises some people. It sounds like legal double talk, but it's really not. Would it surprise you if I told you that you could revoke an irrevocable trust?
Well, it probably would have, except I've been sitting in your presence for a little bit, and now I understand a little bit about how this works.
Well, the trust code is clear on how to do that. It's there's a slight procedure with it. So yes, you can do that. And the other question is, why do we call it a revocable living trust? Seems like a dumb name, doesn't it?
Well,
it sort of implies we're going to do something with the intent of getting rid of it.
It's you lawyers that do this.
Well, I thought about that one time, and I thought I'd look into it because it says, okay, a revocable living trust says, okay, it's like you should have a revocable living trust. It sounds like we're approaching the creation of something with the intention of getting rid of it.
Yes.
Right?
Yes.
So you should have, we're going to make something, a revocable living trust, which means, am I going to revoke it someday?
Yeah.
Actually, how it gets its name. The living trust is easy. It's not like a will that says it comes to life at death. That's what testament means, at death. This is a living trust that goes into effect during life, so we put it in now. That's how it gets the living trust. The revocable is simply that you can change it.
Yeah.
You can change it so much, all the way, you can do 100% amendment to it. You can change it so much, all the way up to the point of revoking the entire thing.
Okay.
That's what drives its name.
Ah.
So you can change it so much.
It's kind of like having a reversible opinion.
Yeah, you can actually release the whole thing and and just get rid of it.
That's amazing.
The irrevocable trust, there's certain, and if you get, people say, well, I don't want an irrevocable trust because I don't want to give up anything. Well, if you don't give up something, you don't get the advantages these trusts offer.
Right.
You can't have your cake and eat it too.
Yeah.
But that income-only asset protection trust we talk about is pretty darn close to having your cake and eating it too.
Well, we ought to take the last couple of minutes and remind everybody about your upcoming seminars and how to contact you.
Sure.
We've got about a couple of minutes left.
We do. And as I said in the beginning, the next seminar coming up is a week from tomorrow, August the 19th. And it's up in Franklin, not too far of a drive. It's a nice place. It's called Suite 501. The actual address that you would put in your GPS is 416 Mary Lindsay Polk Drive, Suite 501, Franklin, Tennessee. And I can't really describe where it is. We've been there once. But I know it's one of these little one-level strip mall kind of things. It's kind of in a business district in a way. Yeah. And it's a place at the very end of the long building. And at the end, it's a nice little place. I like it because it's got huge TV, maybe bigger than the one you got in here. And I don't have to tote my big screen TV for my PowerPoint. We just show up and my laptop and I plug in. Yeah. It's got tables and chairs, holds about 50. They got a little kitchen there. It's a nice little meeting venue. And so anyway, that's a week from Saturday, the 19th at 10 o'clock in the morning.
Yeah.
You can call my office at 931-363-7222, Pierchoski Estate Law, Pierchoski Elder Law, and get RSVP for it or get on the list and come do that. We call it Wills, Trust in the Nursing Home, and that's what we talk about. So after that one, we'll have next Friday will be the day before, and then I'll say when the next one is because they're planned through the rest of the year. I just don't have them all committed to memory.
And your office number?
931-363-7222, or you can go to my website, which is estateplanstan.com. And there you can see my calendar. You can get my phone number or ask a question by email, just whatever. It has a lot of good information on the website, too.
Awesome, good. Always a pleasure, and I always seem to learn something.
Well, good. That's my goal.
That's
Education.
Exactly. Yeah.
Well, thank you for saying that.
I'm sure I'll have more questions.
Oh, hey, I encourage it, man. Bring them on.
Very good. Estate Plan Stan, everybody. Check him out. Of course, give him a call. 363-7222 over in Pulaski, and go to one of those seminars. I'm going to schedule one as soon as I can, too.
LB came to one.
Did he really?
He did. He popped in.
That's awesome. That's awesome. We're going to do it. Thank you, Stan.
Thank you. Always a pleasure, Jeff.
This is WDXE, W287AA, and W237FD Lawrenceburg. Broadcast services of Prospect Communications.